Good afternoon, this is Sean Golden with Golden & Golden, here to discuss the basics of the FBAR and whether it is your first time required to file the form or is it just your first time filing a form that may have been required in prior years. Let's go through the basics. FBAR, Foreign Bank and Financial Account Reporting. Technically it's a FinCEN form, Financial Crimes Enforcement Network Form 114, though it doesn't really have much to do with crime. The FBAR enforces it. It's required by U.S. persons. For individuals, that means U.S. citizens, legal permanent residents, and foreign nationals who meet the substantial presence test. The threshold is if you have more than $10,000 in annual aggregate total. So if you have one account with $500,000, or let's say 8 accounts with $1,500, what's the math on that? 12,000. Yeah. So then, as long as you're more than 10,000 in annual aggregate total, you report all of the accounts. You don't have to have an interest in the account, which is something that's required for FATCA. For the FBAR, it's really just, do you have ownership? Do you have co-ownership? Do you have signature authority? Sometimes you have signature authority because your sweet grandma put you on the account to make sure that you could take care of her because she doesn't trust anybody, right? Or it could just be you're an employee and you have signature authority over an account or somewhere in between. Maybe you work for your grandma, right? There's lots of different types of accounts that need to be reported. Bank accounts, investment accounts, stock accounts, mutual fund accounts, CCOP fund accounts, pensions, life insurance, all of that would fall into the financial account reporting requirement. So first time required. Let's go through an example. Michelle has never had any foreign bank accounts ever, but she started a new company, and in 2020, she opened an account in Taiwan. That account has $400,000 in it. It's now 2021. It's Michelle's first time to file an FBAR. It's the first time she ever had foreign accounts as a U.S. person and first time that it exceeded $10,000. So Michelle is going to file the FBAR in 2021 to report the maximum account value in 2020. Does Michelle need an attorney? Of course not. There's no non-compliance. There's no risk of anything. The fear-mongering and the scaremongering is absurd, and what people try to do in order to get you to part with your money by scaring you into nonsense is ridiculous. But you've done nothing. It's like filing your tax return, right? You don't need an attorney to file your tax return if you haven't done anything wrong. So essentially all Michelle is going to do is put her best foot forward to try to report the maximum account value the best that she can. Depending on what country she's in Taiwan here, so if she has a passbook account, it may be a little more difficult to get an exact balance. They don't all operate like Bank of America, for example, where you get the daily, weekly, monthly statements. You just do the best that you can, okay? It doesn't have to be perfect. Yeah, reasonable search, diligent effort, you'll be fine, okay? No requirement for perfection. Let's say instead Michelle had opened this account in 2010. She hadn't accessed it. She never thought twice about it. It's in Taiwan. She had put $400,000 in there. It's a securities account. It may be generating some income, but it stays within that account. It's never been distributed to Michelle. In fact, Michelle opened that account before she was a U.S. person, so she didn't know she had to file it. Well, Michelle was out with some friends, and Jeffrey Buzzkill explained to her that while they were out partying that she should have been filing the FBAR. Michelle goes home sad and realizes that she should have been filing it for many years, but now she wants to file it for the first time in the current year. Should she just go and file it? Of course not. If she just goes off and files it without properly getting into compliance for the prior years, it could be an issue, right? Michelle, there's plenty of programs available for Michelle, which I'll go through in a minute, but if she just was to go off and file now, without getting into compliance first, that's considered a quiet disclosure. Whether she mass files several prior years or just starts filing going forward, what she's done is taking a non-serious situation and kind of bootstrapped it all the way up to willfulness, right? Because now she knows that she should have been filing, and instead of going through the proper channel, she's just going to go off and file the prior years to avoid any penalties or file going forward, hoping that the IRS is none the wiser. Either one of these options would unfortunately take Michelle from a non-willful situation and possibly put her into a more serious willful category and much higher fines and penalties. For Michelle, there's lots of programs that are available for anyone, actually. So there's several different programs. There's something called the VDP, which is the Voluntary Disclosure Program. That's for people who are either willful or cannot certify under penalty of perjury that they're non-willful. For people who are non-willful, there's lots of different options available. There's the streamlined filing compliance procedures, which is streamlined domestic and streamlined foreign. There is reasonable cause and delinquency procedures. Delinquency procedures changed in November of 2020, so you want to be careful and make sure that you're reading the proper material on that. It does impact the ability to get the penalty waiver. It's pretty much just a reasonable cause statement these days. We have lots of free information available on our websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.